Good afternoon. My name is Norma Bertram and I will be discussing constitutional issues, particularly Section 114 in relation to the case of South Australia versus Commonwealth 1992, reference number 174 CLR 235. Under dispute in the case of South Australia versus Commonwealth is whether income received from investment and sale of capital assets by the South Australian Superannuation Fund Investment Trust were exempt from income tax and capital gains tax under Section 114 of the Constitution. The case was taken to the High Court to decide two issues: whether Cwth could be considered a state under the definition of 114 of the Constitution, and whether capital gains tax is a tax on property under this same section. The judges hearing the case were Chief Justice Mason and Judges Brennan, Dean, Dawson, Toohey, Gaudron and McHugh. Parties to the case were the plaintiffs of the South Australian Government and the South Australian Superannuation Fund Investment Trust, or Cwth, and the defendants were the Commonwealth of Australia and the Commissioner for Taxation. Cwth held assets including investment in government securities, government-secured loans, debentures and notes, land and buildings, listed and unlisted shares, money invested in the short-term money market, and other investment-generating assets, income-generating assets. Cwth is also owned by and operated for employees of the South Australian State Government. Taxes on investment income and net capital gains were levied against Cwth for the period of 1 July 1989 to 19th of October July 88 to 19th of October 1989. The Commissioner considered Cwth a complying superannuation fund under changes to the Tax Laws Amendment Act No. 2 of 1989 and the Tax Law Amendment Superannuation Act of 1986, which removed the exemption from income tax and capital gains tax on trusts and superannuation funds, taking effect from 1 July 1988. Cwth contested the tax assessment under Section 114 of the Constitution on the basis of qualifying as a state and of capital gains tax being a tax on property, and under Section 271 of the Income Tax Assessment Act 1936, or the Act, in relation to trusts. The following questions were reserved on the case. Question 1, whether prior to the 19th of October 1989, was Cwth and is Cwth now the state of South Australia within the meaning of Section 114 of the Constitution? Question 2, A and B, prior to 19th of October 1989, was property held on account of the fund and is property now held on the account of the fund property of any kind belonging to a state within the meaning of Section 114 of the Constitution? Question 3, whether Cwth is exempt from paying income tax on income received into the account from the period 1 July 88 to 19 October 89 by reason of Section 114 and Section 271 of the Act. And question 4, is Cwth exempt from paying income tax in relation to the same assets after the date of 19th of October 1989 by reason of Section 114 of the Constitution? A ruling was sought from the Commissioner by letter on the 12th of December 1989 regarding exemption under Section 114 in relation to Section 271 of the Act. On 18th of June 1990, the Commissioner advised by letter that assets owned by Cwth were property of the state and therefore capital gains tax exempt. However, assessable income from the stated period was not. The Commissioner later advised by letter on the 28th of September 1990 that Cwth was not a constitutionally protected fund and would be required to file annual returns. Under Section 14 of the Constitution, the Commonwealth cannot impose any tax on property of any kind belonging to a state, nor a state on the Commonwealth. The two main issues being argued in this case are whether the tax was imposed on a state by the Commonwealth, contrary to Section 114, and whether tax on capital gains is a tax on property. The Commissioner stated that Cwth is a superannuation fund under the definition in the Tax Laws Amendment Act, as well as being taxable as a trustee under Section 271 of the Act. The defendant also stated that money and contributions to the fund in the form of interest from loans, dividends received on investment, and rent received from leasing land and buildings constituted assessable income under Section 6 of the Act, and net capital gains as defined under Section 160ZC of the Act. Cwth contested that being wholly owned by the South Australian State Government, the assets of the trust were property of the state, and therefore any income and net gains qualified for exemption from tax under Section 114 of the Constitution, and that the defendants had no authority to assess taxable amounts or to impose taxes upon them. This case caused some debate about whether capital gains tax is a tax on property. It could be argued that money is property. However, income tax is applied to income resulting from business activity over a given period and taking into account deductible amounts, not on the funds themselves. Similarly, capital gains tax is applied to the net gain on the sale of capital assets after costs have been deducted, not to the value of the asset itself, and so therefore is not a tax directly on property, but on the transaction of disposal of said property. There was also debate as to whether interest received from loans and other income from investment assets was assessable income, or whether tax on this income was also a tax on property and therefore exempt under Section 114. And to the decision, under Section 114 of the Constitution, the Commonwealth cannot impose any tax on property of any kind belonging to a state. Section 271-20-B of the Income Tax Assessment Act states that if the trustee is a company, then the trustee is liable to pay tax. Judgment was handed down on the 25th of February 1992 as follows. The defendants accepted Cwth as a state by definition under Section 114 at the hearing, thereby rendering all assets as property of a state and therefore exempt from tax by the Commonwealth under Section 114 of the Constitution. As the trustee under Section 271, Cwth is a state, it was no longer necessary to address questions 1 and 2, as mentioned previously. In the first fringe benefits tax case, Queensland versus Commonwealth in 1987, reference number 162 CLR 74, it was held that some taxes on rights exercised by an owner with respect to his property will amount to a tax on property in the prohibited sense, and a tax on the proceeds of sale of property is a tax on the ownership of property. Using this judgment as precedent, it was held by the whole court that Cwth was recognised as a state and all assets thereof were constitutionally protected under Section 114 and therefore exempt from capital gains tax as a tax on property. This was held for both for the period from 1 July 1988 to 19 October 1989, in question 3, and after 19 October 1989 from question 4. Interest received from loans and other income from assets, however, was considered to be derived from the use of these assets and therefore accessible for both periods. This was held by Mason, Dean, Dawson, Toohey and Galdron, Brennan and McCure dissenting. Dawson further explained why money could not be defined as property, given that money received during the course of a reporting period may no longer be in the individual's possession at the end of the period, and only became taxable after allowable deductions had been made from assessable income. Brennan and McHugh judged that this income should also have been exempt under Section 114. In conclusion, the implications of this case for tax practitioners are the importance of having a working knowledge of the Constitution and of keeping abreast of changes to tax legislations and the implications these changes can have on a client's tax requirements and responsibilities. In this case, changes to the Tax Laws Amendment Act No. 2 of 1989 and the Tax Laws Amendment Superannuation Act of 1986 removed exemptions from income and capital gains taxes for trusts and superannuation funds, both of which would have impacted on SASFIT. Seeking clarification from the High Court provided SASFIT's assets with constitutional protection against the effect of these changes by recognising it as a state entity under Section 114 of the Constitution and allowing the assessments to be put aside. It is important for the tax practitioner to be aware of any connection their clients may have to state or Commonwealth, which may affect the application of different taxes to their business affairs. I hope you have found this information instructional, and thank you for listening.